again, this is Ben Hitchcock Cross talking to you today for Deliberate Indifference Wisconsin about Lanita Tate versus Milwaukee Public Schools. I'm going to introduce this case. It appears in 5 parts here. The first part is my direct examination of Miss Tate. The second part continues the examination with cross-examination by the City Attorney's Office. The third part is James Gordon, and for avid MPS watchers, that should be exciting. He is a highly placed HR executive, and he has a lot to say about how the MPS complaint process works. So that should be pretty interesting. It also highlights his interaction with the City Attorney's Office and how they respond to both public records and employee records requests. So that should be pretty exciting. Part 4 is Laquita Hoskins, who is a HR worker who is, in this case, was in charge of putting names on the hire list after others had made the decision. The final part 5, is Miss Renee Beauchamp, who interviewed Miss Tate for the position here that she was not hired for by MPS, and is participated in that decision. Okay, so that should be we'll be putting that out over the series of weeks, and that should be pretty exciting here. So we've got I'd say 3 big things that I want to highlight about this case. I think a lot of the direct examination should speak for itself. But before we do, just so we can frame that, and also for others who aren't as familiar with the MPS process, let's talk about who the real heroes are. So the first thing I want to talk about is this case will highlight the working conditions for custodians and food service workers at MPS. Miss Tate was a custodian for 30 years. She basically complained about her treatment of her supervisor and the lack of resources that she had. She did this in public, and within a couple of weeks, a union representative came to her and told her that she was going to be charged and found guilty. And then, lo and behold, she was charged and found guilty. So, as a result of that, there was a discrimination complaint that was filed with the Equal Rights Division, and then that case was resolved. Miss Tate retired and decided to re-enter the workforce. She applied for work at MPS as a food service assistant because she knew that work because she had been a custodian for 30 years. A custodian, so we're clear, are the workers who are in charge of the physical maintenance of our schools. They do work that ranges from cleaning to the actual maintenance, repairs, really to everything to make sure that it's a safe and clean environment as much as management will allow for our children to go to school. Food service workers, I think that's a little bit more self-evident here. But again, this case is going to highlight how management treats them and the regard or disregard that management has for these workers. I think you'll be able to make that decision quite easily. So, Miss Tate filed for or applied for a job as a food service assistant. You will see from the evidence here that at that time, even though there was some 100 vacancies and MPS was advertising on the local news that it desperately needed food service workers, they were actively discriminating against previous employees, especially those who had filed complaints or have known to have used FMLA or other forms of, were known to be disabled. That evidence, I think, will come out pretty clearly in part 4, but you can make your decision about how you feel about that. The second thing that I want to highlight here is a virtue that Miss Tate exemplifies. That is, she is aware of who her friends and who her enemies are. And I think that is so important, and so much of what I do as an employment lawyer is to educate people especially those in government, about what the role of HR is for them, and who they can trust and who they can, how they can act in their own best interest, and keep that paramount. So I think that there was nothing that I could teach Miss Tate. And I think that's clear both from her testimony, and I'm here to tell you that today. I've met many PhDs, many highly placed employees who we'd think both from their experience and position would have a really clear knowledge of who their friends and who their enemies are at their employer. But I think Miss Tate, even as her role as a custodian, was very clear on that, and we'll see that through the testimony here. The second virtue that Miss Tate exemplifies is courage. And by paraphrasing Maya Angelou, I think we can be clear that without courage, the other virtues are really insupportable, certainly for any amount of time. And that, I think, is going to be clear when I explain to you a little bit more about the first case that Miss Tate had and why she chose in this case to have a hearing. During the first case that she filed for discrimination while she was employed as a custodian, Miss Tate was not represented by any attorney. She participated in mediation, and which broke down. I believe the parties were not very far apart in their numbers. I think, in the relative scheme of things here, we're talking very small dollar amounts in terms of what was being offered and what was being demanded. Okay? So, that being said, they went into what's called a pre-hearing conference. So this is at that time, because of COVID, this was a WebEx or telephone conference in which the parties, meaning Ms. Tate and the city attorney, and the administrative law judge or hearing examiner from the Equal Rights Division, all get on a telephone and prepare for the upcoming hearing. Right? Several things are discussed. But usually the concept is how do we get these documents in front of the witnesses and how are the witnesses going to testify? Well, not in this case. In this case, settlement was not only discussed by the administrative law judge who was hearing the case, the administrative law judge made the decision about what the settlement was going to be. She said that she basically split the difference. Not basically, she split the difference from what was being offered by the city and what Ms. Tate was requesting, and said that's fair. And however Ms. Tate felt about that, I think we can all be clear that if the judge who is handling the case and going to hear the case is telling us a dollar amount before she hears any evidence about the case that she believes is fair, we may think that there's no point in going to hearing because the judge has already made up their mind and we already know what the outcome is going to be, so we might as well save everybody time and trouble. And I also get the impression that that was sort of what the judge was hinting, that that's what she'd prefer, is to not have the hearing as well. So with that in mind, I think the Ms. Tate resolved her first complaint against Milwaukee Public Schools. Well, when she filed again, Ms. Tate was told, or when she applied again, was told that she didn't make the job, and she asked some questions, and the answer that she received was pretty clear, unequivocal, that the MPS had looked into her previous employment record and had decided not to offer her employment. Well, Ms. Tate then promptly got this exact same job from a temporary employment service where she continues to work, I think, some years later, making less money and really having suffered just continuing to work and with fewer benefits and with less pay because she had had the temerity, the audacity to file a complaint with the Equal Rights Division. And MPS told her that in writing. So, come to this case, she gets a probable cause. She goes through the whole process herself, and she gets to mediation, and once again, she feels pressured. Well, at that point, she comes to me. So I think we're about 2 weeks away from the hearing at that point, and we, much I think to the dismay of the city attorney's office, as you'll see here in their face, that we decided to go forward, and Ms. Tate had the courage to have her day in court. I think you'll see the results here, and I hope you like them. Thank you very much.